Thank you for joining us today. My name is Roger McOwen. I'm the director of the Center for Agricultural Law and Taxation at Iowa State University in Ames, Iowa. With me on the presentation today is Christine Tidgren, the staff attorney for the center. And we're going to talk about a very important issue that's come up in recent months in Iowa as well as in other places across the country, and that has to do with companies that are trying to acquire easement rights across private property to construct a transmission line to transmit electricity generated by large-scale aerogenerator operations from one part of the country to another part of the country. And specifically in Iowa, the proposal is to construct a line and acquire easements across Iowa from the northwest corner of the state to the southeast corner of the state. This issue has come up with other companies besides the company that is operating in Iowa to do the same thing in other parts of the country, particularly in Kansas. But this does propose a lot of legal issues, and we want to get into those legal issues today with respect to the proposed agreements that are being offered to landowners. And that's what we're going to take a look at. And our contact information is you have our contact information in front of you. The main line for the center is 515-294-5217. You see my email address, Christine's email address, the center's website address. Plus you can now follow us on Twitter, and you can see our Twitter handle there is @called_Iowa State. And feel free to sign up for to receive the most recent developments. When we post developments to Twitter, you'll be able to get notification of that. Let's get into our topic for today. And I want to start with an overriding principle of contract law, which also governs in this situation, because what we're dealing with is a proposed contract. A landowner is given an agreement by the company that their land obviously is in the path of the proposed transmission line, and the company needs access rights to their property and some legal rights not only to construct the line but to come in and perform maintenance on it. And this is a legally binding document, and so it's a contract, and so basic contract principles do apply. And that first fundamental principle of contract law is that you should never sign a contract, any contract, without first fully understanding its terms and those terms' legal impact on you. And of course, once you do that, and that may necessitate hiring of a lawyer that's well versed in the types of issues that's presented in that particular contract, and once you have an explanation of those terms and understanding of how they impact you, then what you want to try to do is attempt to negotiate any unfavorable terms. Always remember that the party that drafted the contract has drafted the contract in their own best interest. That's just the way things work. That doesn't mean it's necessarily good or bad. It just means it's written from that party's perspective. And from your perspective, you may have a different view of terms, and so you want to try to negotiate terms that you view are unfavorable. Often, numerous terms will require negotiation in order to provide a more equitable agreement or a more fair agreement for you. Let's go through some of the basic points that we see on many of these agreements. These tend to be fairly standardized. What you will typically see close to the front of the agreement, typically in a second paragraph, but this can vary from contract to contract, but typically we see them up front, and that is that this is a perpetual type agreement. It's perpetual, it's exclusive for the purpose of constructing, operating, and maintaining an overhead transmission line. So this perpetual means it doesn't have an end point on it. So you need to understand that this is an agreement that will be binding on you. It's probably going to say it's binding on your heirs, your successors in interest, and it is on that land, and it will run with the land if that land is subsequently sold. So a buyer would take subject to this existing easement. That's the fundamental principle to understand in terms of what that means. Also included in that typical language where it's noted as being perpetual in nature is the easement calculation sheet. And what you will see as an individual landowner is that you're going to receive an initial payment, and it's going to be of a certain amount, and you're going to have to determine on your own whether you view that as adequate for the types of rights that you've given up with respect to your property for this transmission line to be placed on your property. Then there'll be a balance due. And that is the amount that's going to be paid on the earlier of a specified date, typically about 3 years out from the date that you sign the initial agreement, or the date construction crews come onto your property, gain access to your property to install structures or wires. So what you see is there's a period of time that the company has to begin construction, and that is typically 3 years out. That can vary, but what we see most of the time is about a 3-year interim period. And that balance due is going to be paid on the earlier of that date, which again could be about 3 years in the future, or when construction crews access the property to install their structures or their wires. And it's whichever of those dates occur first. But there's no obligation to pay. Typically under these agreements. That seems a little strange. There's an initial payment and then a balance due, but there's no obligation to pay the balance due amount. But failure to do so terminates the agreement. So if payment of that balance due is not made, that does terminate the agreement. So this lets the company basically get an out in case something happens where they cannot put the line up. They won't make the payment. They don't have an obligation to do so. But if they don't, then that terminates the agreement. So it is a kind of a risk protection device for the companies that offer this agreement. Also, what we see is in terms of the easement calculation sheet, you need to consider the amount of compensation that the company is offering you. Understand, as I said earlier, it is a permanent easement, and the productivity of your land is an issue. The payment, while it might be a standardized amount, you need to think about things that could cause this payment amount to fluctuate from property to property that's impacted based on the unique aspects of that particular tract. What I'm saying is that one amount for landowner A may be adequate, but that same amount for landowner B might not be adequate because of unique characteristics associated with landowner B's tract. For example, are seed corn production blocks involved? Damage compensation clauses under these agreements, the calculation in terms of the way damages are calculated, only account for commercial crop formulas, not seed corn production blocks. Now we're going to get more into damage calculations later and the damage clauses. Christine's going to get into that issue a little bit later, but I just want to throw this concept out to you right now. If you start comparing what's been offered to you with what's been offered to a neighbor, and you'd say, well, we've been offered the same thing, it's a standardized contract, that may or may not be an equitable solution in your situation because there may be different production issues going on with respect to those tracts, and there are other damage issues that can come up, and we'll get to those later. But I just want to get you to thinking along that line that it is a permanent easement. Productivity of your land is an issue, and what you're doing on your tract can influence the amount of compensation that you should be receiving under the agreement. Another part of the standardized contract is in terms of the rights that are granted under the agreement. The company is acquiring, frankly, a lot of rights. Typically, very broad language is used. They can construct anything that they want under this type of language. It's very broad language. Also keep in mind, while you might be thinking that the plan may be for monopole construction, there is no restriction on that in these agreements that we have seen. It's whatever is deemed necessary and desirable by the company. And that is, again, very broad language, and you want to think about that. I think that a good suggestion here is to raise that issue with the company that has offered you this agreement to see if that might be negotiable or whether you can pin them down on the type of facilities that are going to be constructed on your property so that you can properly evaluate what type of activities that you're going to be able to continue to perform on your land and not run up against problems with respect to this transmission line that's crossing your property. So while we all may be thinking one thing in our mind mind with respect to monopole construction. That is technically not restricted in the standard agreement. It's whatever is deemed necessary and desirable by the company. Another issue that comes up has to do with the location of the easement. Again, this is under the clause language that grants rights to the company under the agreement with respect to your property. Location of the agreement. Now we're talking Iowa specific here, and for those of you who are listening in that are in other jurisdictions, you're going to have to look to your particular state law. But the standard agreement seems to be saying that the location of the easement will be up to 100 feet on each side of the center line of the as-built facility. So that's 100 feet either way. Under Iowa law, that's twice as big as is provided for in state eminent domain law. So in other words, if a landowner says, no, I'm not going to sign an agreement, and let's say the company does start to exercise eminent domain proceedings and is successful in doing so, they won't get an easement 100 feet on each side of their facilities as they built. They'll go 50 feet on each side under eminent domain procedures. So that perhaps opens up a negotiation point for you if you don't want to grant an easement that's wide. So the company would have to use eminent domain procedures and apply to the utilities board successfully to get up to 200 feet. Because just simply exercising eminent domain is not going to get it for them. They'll have to go through that procedure and then in Iowa apply to the utilities board to get up to 200 feet or 100 feet on each side of their as-built facilities. Plus, under the location clause, as part of the rights granted in the agreement, that location can change. So it is somewhat flexible. The company does acquire a lot of rights with respect to the location of that easement. As we continue on in the discussion of the rights granted in the easement to the company, right of ingress and egress, so the right to access your property, to come in and go out, is also very broad, very broadly worded in terms of the language that's used. Over the easement, over the landowner's property, and they have access also over the landowner's property adjacent to the easement. So it's not just a right of ingress and egress over the easement itself, it's over the landowner's property to get to the easement as well as the property adjacent to the easement. So that's another one of those clauses you want to consider. That's giving up a relatively large amount of rights. You want to make sure you're compensated for that. To the extent that you can narrow down the scope of the easement, particularly the ingress and the egress right, then you can always expand that at later points in time by having drafted into the agreement a change in the legal description that governs the easement. And of course, when you do that, when you open up an expansion of the scope of the easement, you should collect more in terms of your payment. But if you start broad, you can't narrow it down. So you want to, in this sense, you want to start to think narrow and then expand it for additional compensation in terms of the rights that are given to the company proposing to have the easement. I'm going to turn it over to Christine at this point. She's going to get into some damage clause issues and some other issues that come up under these standardized contracts.
Okay, so now we're going to turn to a typical damages clause in a contract such as this. Many of these damages clauses, which would govern what a landowner would be entitled to if their property were damaged, would say that the company might repair or pay at the company's option for any damages to the landowner's improvements, livestock, and or crops. So in this example, the landowner, this is what the landowner would be entitled to. The company would, at its own option, be able to decide whether or not to repair the property or whether or not to pay the landowner compensation for the damage that it caused. And in this particular case, the damage is only compensable if it's to improvements, livestock, or crops. So this particular clause does raise some questions. What if you receive damage to your pasture ground or your CRP ground? What if the soil's compacted? This provision would not seem to require the company to compensate the landowner for that damage. What about landowners who use GPS technology and the the lines interfere in some way with that, is the landowner entitled to compensation? Under a general damages clause like this example here, it would likely, the landowner would not be entitled to such compensation. So these are questions to ask any company trying to negotiate a contract with you. What about aerial application of pesticides? What if the poles somehow interfere with that? Is the landowner entitled to any compensation for that? Again, in a generic damages clause cited here, the landowner would not be. So these are all important questions to ask, and also important provisions that are negotiable. So remember, when you're handed a contract, you do have the right to negotiate these provisions and ask these questions. Now, in this particular example we gave you, the Iowa eminent domain statute would actually provide the landowner with greater protection. Iowa chapter 478.17, for example, requires payment to owner of such lands and of crops thereon all damages to said lands or crops caused by entering, using, or occupying the lands for the eminent domain purposes. So under the eminent domain statute, the landowner would be entitled to damages to all of the owner's lands and crops, and not just livestock improvements and crops.
That's a good point, Christine. On that livestock and crops issue, we raised the question, and you mentioned it here, what about pasture ground? There was a Kansas case a number of years ago involving a similar issue, but that one was an oil and gas lease case. And the damage clause in the oil and gas lease said that the company was responsible to restore they were responsible for damages to crops if the pipeline wasn't buried below plow depth. Well, what happened was that you had a pipeline that was buried below a pasture that was grazed, and the court was faced with the issue. Of course, the company didn't want to pay for damages because they said, well, this only applies to cropland because we had to bury it below plow depth, and you don't plow a pasture. And the court ruled for the company, saying that's correct. A reference to crop depth, a reference to plow depth is a reference to cropland, and it didn't cover damages to pasture. The Iowa statute, as you point out here, seems to get around that problem if you go through eminent domain, because it deals with such lands and crops thereon. So it would appear that that deals with the issue of the land in general, as well as any crops that are also on that land. And that's different language than just saying we're going to pay for any damages to your improvements, your livestock, or your crops. What about pasture ground? And that's really what we want to emphasize with respect to that issue. That's one of those things that you want to talk to your legal counsel about to see if you might be able to tighten that language down a bit.
That's an excellent example. One thing that these typical contracts do grant to the company is the right to clear the easement of any buildings or other structures except for fences, and also to control, cut, and remove all trees and underbrush. And so in a typical contract, because the company has the right to go in and eliminate any buildings or structures or brush or trees, they're also not going to have any liability to the landowner for anything that happens from the clearing of those buildings. So that's something to watch out for. A typical agreement would assess no liability to the company for any damage arising from clearing the easement of buildings, structures, trees, or underbrush. Now, most agreements would provide for damage to the landowner for drainage tile that's damaged. So you need to watch for that. You need to see if the agreement specifically addresses drainage tile. But in a typical example, the company would either repair, replace, or pay the cost to repair or replace to the landowner. And in this example, that choice of whether the company is to repair or replace or just grant monetary compensation to the landowner is at the landowner's option. So that's a fairly favorable provision there in the case that the company would damage drainage tile. Now, under these easement agreements, the landowner does retain the right to use the easement property. It's just subject to not interfering with the company's rights under the easement. So under a typical agreement, the landowner would retain the right to use for normal farming and grazing purposes the land that's subject to the easement. But even so, that usage is always subject to not interfering with the company's rights under the easement. And we'll get to more of that a little bit later. But these agreements do allow the landowner to install and maintain fences, because that's important. However, they provide that the landowner must continue to allow the company access through a gate. So this means that if there's just a fence, there will need to be a gate installed. And a typical agreement will require the company to pay the cost of implementing that gate, and that gate needs to be at wide enough for the company to access the property. The agreements generally also provide that the landowner shall not engage in any activity that would interfere with the company's use of the easement. And in some cases, they'll allow that to be possible as long as the landowner receives prior written consent to that use. But some specific uses that are typically banned are drilling or operating a well, building or constructing property. Again, if you have granted an easement to a company for one of these clean lines, you are not going to be able to build on your property. And as we discussed, they have the right to wipe out any buildings that are already on that property. The landowner typically will not be allowed to change the grade of the property or install any utility lines. Now, one important thing to look for in these agreements is what is the landowner required to do during the initial construction phase, or whenever there's a period of time when the owner needs to access the easement for some major work on the facilities. These are interesting because these agreements typically provide that no landowner access is available for any purpose during the time that the company needs to access the easement property, either during that initial construction phase or at any time when there's major work being done. Now, this is fairly vague general language, and there's no guarantee to the landowner when major work on the facilities may need to be done. There's also typically in these agreements no provision stating a length of time that this initial construction phase can occur, or a reasonable period of time during which the major work on the facility must be completed. So these are interesting questions, again, to ask the company, to negotiate with the company, to make sure that you're not going to be shut out of your land during planting season, when you need to get in there to harvest your crop. For maintenance of drainage tile. As we already discussed, drainage tile will remain on the property, so what if there's a maintenance issue that you need to access that? And also just for general control of weeds. So these are really important questions to ask the company when you're negotiating this agreement.
Those are all good points, and it does point out again a number of issues that may need to be negotiated through your legal counsel when you're thinking about signing these agreements. Again, always make sure that you understand the agreement before you sign them. You just don't want to rush in, and I hope and while we've gotten just part of the way through the presentation, that you're starting to understand that point very clearly right now. Let's move on to cancellation rights under the typical agreement, and what we're seeing here is a provision that allows the landowner to cancel within 7 days from the date that they sign the agreement. However, the company retains the right to cancel the agreement at any time, and then they have 6 months, typically a 180-day provision, to remove any structures or facilities that they have put on the property. So that is different. The landowner having 7 days, the company having any time after the agreement is signed to cancel, and then having 6 months to remove any structures that they have put on. There's also typically a 5-year non-use provision contained in the agreement. So if construction is started and then it's abandoned and there's been 5 years of non-use, then that cancels the agreement. Also relatedly to that, if construction is begun and work then ceases and is not resumed, so it hasn't been abandoned, it just stops, and it's not resumed, again the 5-year provision kicks in at that point. Foundations, in terms of removing structures, there is language in the typical agreement that says that any foundations that have been put in are to be removed only to the depth at which there would be no more interference with existing land use. Now we highlight in bold and italicized the word existing. That's the word that's used in the agreement. So if your existing land use at the time that the easement was granted and the transmission line is put across the property is pasture, that's going to be a little bit different, obviously, than if the ground is used for crop production purposes or for other purposes. So what if you're converting from a pasture operation to crop farming? Now you've got foundations that are in there because they weren't removed at a very great depth because the existing land use at the time of removal was pasture ground. You need to think about that. Think about future restrictions on different types of uses of the property and how that might impact you economically, and make sure you are economically able to recover that cost. Make sure that you are paid for that potential loss of use of that property. Notices, in terms of giving notices under the contracts, these notices have to be given in writing, and they are either done by personal delivery, receipt in the U.S. mail, or the contracts state by courier service 24 hours after delivery. So that's fairly standard. I can't see that one as being negotiable at all. It does make sense to have notices in writing and to specify the manner in which the notice is to be given, and you can see the 3 options for giving those notices. Assignment of rights. Under the contracts that we've seen, particularly the ones in Iowa, the companies retain the ability to assign, mortgage, or lease the rights that they've obtained under the agreements at any time. And this is very common. We've seen this in the past with the straight-up wind energy contracts, where you're dealing initially, a landowner will be dealing with a prospecting firm that comes out, signs the landowner up, and then that agreement is assigned to some company, typically a foreign company, that will come in and construct the related towers with the turbines. That's the same issue here. The prospecting company, the initial company you deal with, has the ability under these agreements to assign or mortgage or lease their rights at any time. Once they do so, they're released from their obligations under the agreement to such extent if the buyer, assignee, or lessee assumes that company's obligations. So it's a release and an assumption of those obligations, which will, by a subsequent company, which will release the initial company that you've signed the agreement with from their obligations under the contract.
These contracts do also provide that these easements will run with the land. Now what that means is that if you sell your property, your buyer will also of course be subjected to the benefits and the burdens of the easement. So these don't go away, they're not personal to you. And the agreements do also provide that any assignee or any assignee of the company itself also has the benefit of the easement as well. Now, any contract that you sign or that you review is going to have a choice of law provision, and whatever state you're living in would be the law that would govern, but the contract also provides that. So the contracts we've seen in Iowa do provide that Iowa law governs. And then they also provide specific time frames within which a landowner can actually terminate the agreement in case there is a breach. And so a typical provision would provide that if there's a breach of a monetary obligation, meaning that the company doesn't pay when they're supposed to. So typically when you sign the agreement, you get the down payment. But then, as most of these contracts provide, at the time that construction begins, then the company needs to pay the balance due to the landowner. If somehow that doesn't happen and the company's in there constructing on your property and doesn't pay you, then the contract provides for a 30-day cure period. So what happens is the landowner needs to provide a written notice to the company saying, hey, I need my money, pay, and then the company will have 30 days from receipt of that notice to cure, or in other words, pay. Now there's a different provision in the case of a breach of a non-monetary obligation. In those cases, the written notice must be provided, and then the company has 60 days from the receipt of that notice to cure. And then if it's the kind of breach that can't be reasonably cured within 60 days, then the company will still be okay. The contract can't be terminated so long as the company begins the cure within 30 days and then continues to cure the problem until completion. So this could be any sort of problem that arises under the contract where the landowner believes that the company is not following the provisions of the contract and sends notice to that company. So there is a little bit of a different cure period there for those non-monetary breaches. The landowner does have the right to terminate the contract, as we said, if the company has not cured the problem after the cure period expires. But there is no right to terminate for a breach until that proper cure period is given. Now, these contracts do also provide that the parties agree to settle any dispute via good faith negotiation. Now, this is important to point out because a lot of contracts will require arbitration or mediation or alternative dispute resolution. But in these contracts that we've seen for these clean line easements, there is no such requirement. So if the parties aren't able to resolve differences that arise, then they're entitled to pursue any remedy available at law or in equity in the state and federal courts in Iowa. And these are for those Iowa agreements.
There's also an indemnification and waiver paragraph in the standard contract, and under that agreement, the company that is seeking to have an easement placed on your land and obtain the rights associated with it is to indemnify and hold harmless the landowner from, as they say, any and all liability, claims, suits for injury to persons or damage to property caused by that company or their agents in exercise of the company's rights under the agreement. However, it goes on to say that indemnification and hold harmless provision does not apply to claims associated and resulting from the landowner's breach or negligence or intentional misconduct. Now, I frankly think that raises a number of questions that you need to talk to your legal counsel about. I would be concerned about potential premise liability issues as to whether they're covered or not. Is that a landowner's breach or negligence or intentional misconduct of the landowner when you have a third party that comes on the premises and creates a liability issue? Is that covered or not under this provision? Is the company going to indemnify and hold the landowner harmless from actions resulting with and associated with premises liability? Also, the company's employees could sue the landowner perhaps for negligence, and if that's the case, there would be no indemnification as this is presently worded. So I would want to talk to my legal counsel about that if I were a landowner thinking of signing one of these agreements to see what their thinking is with respect to the meaning of that language. Again, there is no right to mediation or arbitration on these issues. That is not specified in this particular clause language. Also, the companies do not waive legal claims against the landowner arising from, as we mentioned before, the landowner's breach, gross negligence, or intentional misconduct. That, again, just to reiterate, they are not waiving any legal claims that they might have against you as the landowner arising from your breach of the agreement, any gross negligence that you've committed, or any intentional misconduct. So again, be very clear on what is being waived, what the indemnification clause means, what they're holding harmless and what they are not. These are the major issues of which they are not waiving any legal claims against you. There is a subordination clause. This typically shows up in the common agreement later on. Here we show it as paragraph 12, where the landowner is allowing the company to contact lien holders to secure subordination agreements or what's known as a non-disturbance agreement. I would view this as rather standard language. I don't think you're going to be able to negotiate this provision at all. They want to make sure that if there are other creditors that are out there, that they're not going to be impacted by that if something would happen where creditors' rights may come to the forefront. So the company is able to contact lien holders in this situation, those other creditors, to get a subordination agreement from them, or an agreement that they will not disturb the facilities or structures or any of the work that has been occurring on the premises related to the transmission of this clean line energy. Another paragraph that's typically included in these standard agreements is known as a release and waiver. It's a release and waiver of all the rights and benefits under homestead laws. That will vary, obviously, from state to state in terms of what is defined under the homestead. In Iowa, that has a particular meaning to it. From personal experience, I know that's different in Kansas. But this is a release and waiver of all the rights and benefits under homestead laws that may come up in various situations. Again, rather standard language, probably not going to be negotiable on that one. Not sure that's that big of a deal, but again, that is something you want to visit with your legal counsel on to make sure you're comfortable with what that means and in having that provision in the agreement as is. The eminent domain procedure, at least in Iowa, the company that is proposing the clean line is Rock Island, and that is a private company. It's an investment firm rather than a regulated utility. This could be a different issue in other states depending on the type of company that is proposing these agreements with respect to various landowners. But Rock Island here in Iowa is a private company. Now, normally eminent domain procedures are limited to governmental bodies. The government has the right to take your property from you as long as they pay you for it. That's what the Fifth Amendment is about. We can't stop the government from taking our property, but at least the Constitution says if they do so, they have to pay us what's called just compensation. The question arises here as to whether a private company can exercise eminent domain. Some of you may remember a rather prominent U.S. Supreme Court opinion several years ago. It's probably been 6 or 7 years ago now, where the U.S. Supreme Court did allow a private company to exercise eminent domain on the rationale that there was a public purpose to the taking, and that was to expand the tax base. That's kind of a stretch. The court has been heavily criticized for that, and in light of that, a number of states started to amend their takings laws to make sure that private companies could not do that. The first thing that you would want to check and have your legal counsel check is to see what your particular states have done with respect to eminent domain, and whether, if you're dealing with a private company, whether that company is even qualified to utilize the eminent domain procedures. Some states have changed their laws. The U.S. Supreme Court, in their rather controversial opinion, according to some, indicated that they were leaving this up to states to do with what they wanted at the state level. So in Iowa, you can petition the Utilities Board, or the company that is a private company that's trying to put in the clean line and get these rights over private property, can petition the State Utilities Board for permission to erect, operate, and maintain a transmission line. There'll be a hearing. You can show up at that hearing. If the franchise is granted by the board, it vests the company with the power of condemnation to the extent the board approves and finds this whole project necessary for a public purpose. And that's how they have to, that is the procedure by which they comply with the eminent domain law. In the Iowa Code, that is all in chapters 478.6 as well as 478.15. So that is a state law specific procedure. And if you're listening to this presentation from outside of the state of Iowa where you're having this issue come up, you need to run this through your particular jurisdiction's set of rules and make sure that you have your legal counsel go over that issue with you. If, again, you're dealing with a private company, can that private company exercise the right of eminent domain under that particular state's laws?
Okay, that's a summary, a very general summary of some of the provisions in these contracts. And now we'd just like to turn to some of the common questions we've received here at the center regarding these contracts and try to answer them, and hopefully we'll address many of your questions in doing so. So the first question is, must one of these companies file a bond to guarantee future payments to landowners under either the agreement or via eminent domain? Well, the contracts that we've signed or that we've seen, there is no provision for a bond. However, the way the payment provisions work, the landowner does receive a down payment at the time the contract is signed, and then the landowner must also receive the final payment at the time the company would go in to actually begin construction. So that's a protection for the landowner there. And then if the company has not paid as required under the contract, as we discussed, there is a 30-day cure period, and then the landowner at that time can cancel the contract. So the contract really is set up such that a bond is not really a necessary requirement. The eminent domain law makes no mention of the amount of a bond. It does say that there can be a bond in such amount as the board shall approve. So that's pretty general language in Iowa, so it's sort of up in the air whether or not a bond would be posted, or if so, how much that bond would be. Another question that we've received is, what are the landowner's rights if the company stops using the easement? And Roger did mention this briefly earlier in the presentation, but under the standard contracts that we've seen, and under the eminent domain statute as well, the land does revert to the landowner if there is a 5-year period of non-use. So if the company either abandons the property or stops using the property for a 5-year period, then the landowner is entitled under both these contracts and under the Iowa eminent domain statutes to have the easement will terminate at that point, and the full rights revert to the landowner. Okay, another question. Would there be a difference in the title obtained by Rock Island or whatever company would be obtaining this easement through eminent domain as opposed to a contract? Well, both contracts and eminent domain would grant an easement only as opposed to a fee simple interest. So it would seem that under either eminent domain or a contract, the company itself is going to only obtain an easement. Now, as Roger discussed earlier, the contract provides that the width of that easement is not to exceed 200-foot wide strip, whereas the eminent domain statute in Iowa does require an extra procedure for the company to acquire that wide of a strip. And the board would have to determine that there was good cause for that, and it would only be granted in those cases where a 200 kilovolt line or higher was installed, and only if in addition to that there was good cause. So it would only probably be in the width of the easement where there would be a difference, but the title itself, there would be no difference between the contract and eminent domain. And I believe the final question is, should a landowner negotiate the best possible easement contract, or should the landowner force the company to use eminent domain? Well, this is kind of the million-dollar question, but I think our answer would be that if an informed landowner, if you've met with legal counsel, if you've gone through this, you've negotiated the provisions, and you're satisfied as to the fairness of the terms of the contract, eminent domain will not likely provide you any greater rights, and it may actually result in lower compensation. You also have to remember that in an eminent domain proceeding, you're likely going to hire legal counsel, you'll incur legal fees, and there may be other costs associated with such a proceeding. So on the other side of it, a landowner should never feel forced into accepting prejudicial terms to avoid the unknown and the expense of eminent domain.
Christine, let me add one thing here. We just learned something at the center, in fact, today, in going through some of the cases that we go through on a daily basis, that there may be some states out there, such as Minnesota, and this happened to be a Minnesota case, that could kind of come into play on this issue as to whether you try to negotiate the contract to get a better deal, or whether you force the company to use eminent domain. Minnesota, interestingly enough, we were not aware of this until we saw this case, and in fact it just came out, an appellate opinion up in the state of Minnesota. They have what's known as the buy the farm statute. Christine, you want to explain a little bit of what was happening in that case? And we do have it posted on our website now. But that could be, we don't have a similar statute in Iowa, but it could be an issue that maybe other states have. We haven't done the research on that yet because the case just came out. But Minnesota's got this interesting statute.
Yeah, it's a really interesting statute, and it would apply to this exact situation if Iowa had such a statute. But under the buy the farm provision, a landowner actually in an eminent domain proceeding has the right to request that the company purchased its entire contiguous parcel of land as opposed to just an easement. So for example, let's say that the company has been trying to acquire an 8-acre parcel of land, an 8-acre strip of land through the landowner's property as an easement for the implementation of these lines. And the landowner and the company aren't allowed, they don't get anywhere with negotiations, so the company resorts to eminent domain proceedings. Well, in Minnesota, in those eminent domain proceedings, the landowner can say, you know what, I don't want you just to have an easement in that 8-acre parcel. Instead, I want you to buy my entire 300-acre parcel. It's all contiguous, and you need to compensate me fair market value for that entire parcel. And so that's a really interesting option and right that landowners have in that state.
That kind of statute would change the economic equation for the companies substantially. Again, we're not sure how many states have that. That's one thing that we might look into in the future, but that is posted on our annotation list on the website if you're interested in that, or if you're from Minnesota and you're dealing with this issue. But in conclusion, I just want to reiterate, and I think both of us want to reiterate this, make sure you always read and understand any contract before you sign it. That goes particularly with what type of agreement we're talking about today, but any type of contract, before you put your name on it, make sure you read it and understand it. And if there are unfavorable terms, try to negotiate those unfavorable terms to make them more equitable to you. Because it is a well-negotiated and fair agreement that provides benefits to both parties, and there may be an opportunity for not only the company but you to benefit from this type of an agreement. But keep in mind, the converse is also true. If you don't negotiate and you don't have a fair agreement, that's probably not going to provide benefits to the party that didn't want to negotiate the agreement. So negotiation is the key. Making sure you read and understand the contract before you sign it is absolutely critical, and we would encourage you to do so. To the extent you can get a better agreement, to that extent you're going to enjoy the benefits of the agreement that much further out into the future. But thank you for joining us today. Again, here's our contact information that we had up earlier in the presentation. The office main line here at the center is 515-294-5217. My email address is simply mcohen@iastate.edu. Christine's email address is ktidgren@iastate.edu. The website address, you could just do a general Google search for CALT, and it'll pop up probably as the first thing listed there. Otherwise, the address is calt.iastate.edu, and then you can also follow us on Twitter @calt_Iowa State. But thank you again for very much for listening in today, and on behalf of Christine, I do want to thank you for participating in this. If you have questions, feel free to contact us at any time. Additional questions that we didn't address, or anything perhaps that we weren't clear on today, feel free to contact us, and we'll do our best to get a response back to you in a timely fashion.